Afternoon. My name is Sherry Sutphin. I am the magistrate for the Seminole County Code Enforcement Building Department. The way that this process works is you will come up and have a seat. The county will present its case first. It will present any evidence or witnesses that it has. It will then be your opportunity. You can cross-examine at that time. You just cannot present any evidence or witnesses until the county has closed its case. Once the county has closed its case, it will be your opportunity to go. You can then present any witnesses or evidence that you have for your case. I will make a decision here today. If you're here for the first time, for a first-time violation, and I find that there is in fact a violation, you'll be given a period of time to correct, and you stand to have a penalty imposed of up to $250 a day. If you're here for a repeat violation or the second time or even more, then you stand to have a penalty imposed of up to $500 a day. We do have an agenda, but there's really no rhyme or reason. Well, we have a rhyme or reason, but we don't usually go in order, so bear with us. You will be called if you are on the agenda. And I do, if you have not gotten with the county, please come up here, get with the county and sign in, because it's very important that we know that you're here, because we do call the cases related to people that are here first. So, okay, we're going to go ahead and get started. The first case that I'm just going to recognize for the record, 2313 CESM, Sophia Nassim and Irma Chowdhury. That case is actually in compliance, so we will not be hearing that case. The next case that I'd like to call is 2277 CESM B&B Land Holding LLC. James Betts is the registered agent.
Good afternoon.
Good afternoon. Okay, we're going to go ahead and swear in witnesses. Sir, if you could raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Yes.
Okay. Please proceed.
This is case number 2277, CESM, B&B Land Holdings LLC, James Betts. This case was originally heard by a special magistrate on October 13, 2022, and an order was issued giving the respondent a compliance date of January 12th of 2023 with a fine of $50 a day to continue to accrue each day for the violation if the violation continues or is repeated after January 12, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on January 24, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on August 6, 2024. The administrative cost to process this case for the inspector totaled $741.80. The administrative cost for the clerk was $164.23, totaling $906.03. Recommendation is asking the Special Magistrate Board issue an order constituting a lien in the amount of $28,750 for 575 days of noncompliance from January 12, 2023 through and including August 8, 2024 at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after August 8, 2024. That completes my presentation.
Okay, and in front of the PowerPoint that you have in the electronic case file shows the original case and the findings from the original case. Is that correct?
Yes, as far as I know, yes.
Okay. And you were out there yesterday? And checked the county system to verify that there was not a permit?
I checked the county system, yes. I didn't go out there anymore.
Okay. Okay. Do you have anything further?
No, I do not.
Okay, thank you.
Good afternoon, Madam Magistrate. My name's Kara Ann Groves. I'm here on behalf of James Betts, who's one of the owners of B&B Land Holdings, LLC. So as was stated, this has been going on for some time. It's been over 2 years now. So this was from March 2022, and I've been involved for about under 30 days. I'm really here because he takes good care of my dogs. This violation came about as a result of a wall that he constructed in the back to lessen noise of the dogs to the neighbors. So when he bought this property about 5 years ago, this dog resort had been around for about 25 years. And unfortunately, he bought the place as is. And so he buys the property, and he goes around to the neighbors, and obviously the dogs are louder, and he tries to construct this wall to lessen the noise. One of the neighbors complains, and that's how this was brought to code enforcement. And so he very promptly in 2022, initially he was going to go through a roofer that told him that he could do it. They disappeared, and about, I think, August of 2022, we put this in the record earlier today. I sent a copy of the general contractor's agreement. He enters into a contractor's agreement with Dave B. Howell, LLC. And so that's around August of 2022. And at that time, at least from the project workflow and comments that we were able to get from the building department, there were some permits submitted for this purpose. Now, Mr. Howell has done a lot of things that were improper that I'll get to in a minute, but the right thing that he said to them in the first place was when we submit plans, we should submit it for the whole property. We shouldn't just submit a plan for this back wall. And that's really where the trouble has come in. So you can see in the description, James, if you don't mind, of the violation, it's related to this masonry wall and electrical conduit. What ends up being submitted are site plans for the entire property. So this is in August of 2022. You can see from the workflow comments that it gets dropped. And as you know, with contractor licensing, I'm not sure how much you're aware, but there are violations for contractor licenses related to delays and abandonment of projects. In this case, my client paid more than 10% of the deposit for the work done. It was not completed in the 90 days required under the statute. And we also believe that this contractor may be using his father's license inappropriately. So all of that to say that he dropped this matter entirely for a period of time. There are efforts through August, through 2022. We have some text messages where my client is trying to stay involved and make sure that this is getting resolved, but it continues to fall off. One of the other members of the resort is a private investigator and was able to find a slew of files and complaints against Mr. Howell, the contractor. So there was obviously multiple violations in terms of it never got remedied. I'm not sure how much Mr. Betts was aware of that. He's here to testify on that. But ultimately, when the final $28,000 fine notice was sent, that's when I was informed about this and got involved. So we immediately sent a demand letter to Mr. Howell. We said, you have, I think, 14 days to comply. We're required to do that under the law. We gave him the compliance date. He apparently went behind our backs and tried to continue to submit the permits. And so we opened a complaint with the Contractor Board of Seminole County. And I submitted in the record that the building department seems to have acknowledged and opened an investigation against this contractor. And so he does not respond to us. I've called the engineer as well, not responsive. So what we've done is we're switching contractors. And so I have with me today the affidavit of non-consenting contractor, and I've notarized it. It's good to go. We have another contractor. And so really we're just here, certainly at the mercy of the county because it's gone on for so long. But we would ask that the fine be reduced so that he can use those dollars to actually implement at this property some of the issues that have been raised in the plans that have been submitted. I believe that there's more than just the wall issue. There appears to be a firewall issue. No, it's being addressed. And so we're here today because unfortunately there was a long time of a belief from my client, a good faith belief that this was being done. It was not being done. And at this point, he's trying to do the right thing with my involvement. And we would ask for the fine to be reduced, certainly can pay the county's costs, and 90 days for submission of the finalized updated permits. And that's all I have.
Okay, so you believe it'll take 90 days to submit permits?
I think that it'll take closer to 30 to 60 to actually have the contractor to have them all done by his own engineer, because the engineer's going to have to take the site plans already in place and look at them, and apparently they're not appropriate. And then from that time, giving the county time to give comments back. So just factoring in the 30 days for each party to do what they're required to do.
Okay. Does the county have any concerns with 90 days for the plans and a permit to be issued?
No.
Do you believe that that's a reasonable amount of time, or do you think it could be done sooner, or?
I believe that's reasonable.
Okay. I'm going to find, based on the information that you have presented, I am going to go ahead and accept the electronic case file into the record, since you referenced it as well. I'm going to find that your client has, in fact, it appears that they have been, he was under the impression that something was being done that was not being done. But because he didn't follow up with the county, I'm going to take you up on the costs, because I think that that's necessary under the circumstances, and I would urge you just to remain in contact with the county at all times. If you're not hearing something from your contractor, call the county and let them know. You can contact Jason at any time. His information will be on the order that I enter, and as long as you're keeping him abreast of what's going on, he's going to come here and he's going to say those things to me, and so you wouldn't need to, you'd have the evidence right here with the county. So I appreciate that you've taken these efforts. What I'm going to do is go ahead and extend the compliance date to, let's do, if I do 90 days, that gets us to the November meeting, which would be compliance with the receipt of a permit by November 13th, which is the day before the meeting. So you would need to come here on the 14th if for some reason he's not in compliance. And I'm going to order that the county's costs in the amount of $906.03 be paid within 30 days, or it will be imposed as a lien against the property. Okay, thank you.
Thank you.
Thank you.
Let's go ahead and call his back-to-back. He's got two, yeah, let's, 2367 CESM, Efrain Lima and Kelly Andres.
I just need that's.
If you want to go ahead and give him, you can go ahead and give him the other one as well. We'll call it back-to-back. The- Y'all ready?
Yeah.
Okay. Good afternoon.
Good afternoon, Your Honor. For the record, McGregor Love from Lowndes, 215 North Yola Drive.
Thank you.
Didn't want the record to reflect that I was
You're
the
not Tricia Johnson.
county manager. Would staff like to go through its presentation first?
Yes,
Thank
please.
you.
Do we need to swear him in?
No, he's an attorney.
Okay.
You're all good.
Sorry.
No?
We're doing 67 first? Okay, yes. This is case number 2367, CESM. Ephraim Lima and Kelly Enders. And this is property located on Lowry Drive. This case was originally heard by the magistrate on November 16, 2023. An order was issued giving the respondent a compliance date of July 10, 2024, with a scheduled meeting July 11, 2024. An order was issued on July 11, 2024, extending the compliance date to August 7, 2024, with a meeting schedule for August 8, 2024, which is today. An affidavit of noncompliance was filed by the inspector after reinspection on August 6, 2024. The estimated cost for the inspector was $859.79. The estimated cost for the clerk was $96.36, totaling $956.15 for both the inspector and the clerk. Recommendation is special magistrate issue an order reducing the fine to an administrative cost totaling $956.15 in order these costs to be paid within 30 days, or a fine will continue and a lien on the property.
So was the property in compliance yesterday or not?
No.
So then my fine would go into effect as well. You don't want the penalty reduced. Are you asking for fees in addition to the fine from my original order?
I believe that's what should have been on here.
Okay.
Correct.
Okay. Do you have any further information
I have
that you'd
no
like to
further
add?
information.
Okay,
And Your Honor, no objection to this being entered into evidence.
okay, thank you.
I'm going to start with what happened the day after the last hearing we're at, because I think that kind of informs where we are today.
Okay.
You may recall that your order for at least one of these matters, but applied to both, was that Mr. Pike, the building official, mentioned that there might have been some change with the electrical service to the property. A 60-amp temporary service was approved, but the 400-amp that serviced the actual living space was turned off by Mr. Pike during our initial hearing process, and the Limas moved out of the property. I informed my clients of this, and I actually wasn't available during the window where Mr. Pike was available, and let him know that he could go on the property and inspect it. My clients actually went over there, which, as probably any attorney in that position would feel, I felt a little bit nervous about them being there. But fortunately, what happened is that they were able to, by all accounts, have a fairly open conversation about not only the electrical issue that was at issue that day, but the rest of the process. And that's what I've been working to explain to them, what it means to go take the existing permits, cancel them, and then restart the process. I think that they had a productive conversation about that. And my clients have started the process of getting together the documents they need to actually submit that. And I think the first item, and I talked to Mr. Pike about this morning, just to confirm, the first item is a kind of updated site plan. And that's something that they're working on right now to evaluate. But I think the conversation they had with the building official, while I was nervous about it, gave them a sense for what the path forward looks like, and it not being as onerous as they might have initially thought. So I do think it was productive. And just as a footnote on the electrical issue, and I talked with Mr. Pike about that this morning again, at some point Duke turned back the power, turned the power back on without, the involvement of my client. Mr. Pike asked them for an explanation of why that was. It had their sort of stamp on it. I'm not a technical expert on this, but it seems clear that it was, in fact, Duke Energy. And as of this morning, Mr. Pike has not received a response from Duke Energy, but just wanted to let you know where that issue ended up. And my clients had no objection to that being turned off that day, and it was indeed turned off that day. Okay. So for the rest of the process, no new application has yet been submitted, and this will be probably several month-long process, as I'm sure that you can appreciate. I can appreciate that you don't just want to give us another 6 months to take care of this, and that a check-in would probably be warranted much sooner than that. So I would ask for some amount of time, with the understanding that, I don't think it's reasonable for me to request the entire time it might take, because during that time you may not know what's happening or if any movement's being made. So I'd be happy with 2 months, even 1 month if you'd like to check in, and I can give you a description of what we've done in the interim. But the work leading up to a new permit submittal is happening.
Okay, so let me hear from Mr. Pike. I see that he's arrived. Can I go ahead and swear you in, sir? You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Bob Pike, for the record, Seminole County Building Official. Sorry I was held up. I had gotten a call, so.
You didn't know I was going to call this case early anyway. It's
No.
okay.
Neither did I.
If I could clone myself, I would have.
Right.
But, when I went out there, I had Mr. Rucker with me because the power had been turned back on. We met with the Lowrys out there. They did grant us permission to go on site. Also had the power company supervisor out there. He had no answer on how it got powered back up, but they had removed the power for us as directed. I let them keep the 60 amp. He did run some extra wiring to he said was for a future generator. I had him remove it out of the temporary 60 amp service, but I did tell them they needed their site plan right then and there. They needed to get working on it. That was what was needed. And they said that they had a site plan. And I said, well, you need to get with planning and zoning immediately and get that submitted. But I just checked this morning and we don't have anything from planning and zoning for that. So they've basically not done anything at this point.
And I can clarify on what, because I've had this conversation with my clients as well about a site plan. They have had a site plan done. My understanding is that what the county needs at this stage is a site plan that reflects all of the existing improvements, and I don't believe that we have one that shows all of the existing improvements. They have those site plans that were created around the time that work was done previously, but I believe that they need a site plan that reflects everything as it is today. They do have an updated topographic survey that was conducted in April of this year, which we'll include with our submittals, but I believe we need a more recent site plan than the one that they have.
Okay, let me get some additional testimony. If you'll raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Megan.
Megan Zanorsky, planning. So your clients were provided a letter beginning back, I believe, the first time was December 19th of last year, which outlined exactly what they needed on their site plan. They have multiple issues regarding fill, the changes to the property with the related structures. There's multiple layers to the site plan, which is why we outlined from all of the various divisions in development review that need to be addressed with the site plan, which is why it needs to go through the second floor and not just, we're treating this slightly different because of the layers. They don't need a site plan for their building like a typical survey. They need a site plan through planning to submit back with their building permit. So they're gonna need an approved planning site plan before they can obtain their building permit.
And just for clarification.
So if you would like, I'd be happy to provide you a copy of that letter that outlines for your sake so that you have a full scope, because our development services team put a lot of work into providing them the detail because there's multiple structures. And there's some additional information I'd be happy to provide you with outside of the hearing, so we're not taking hearing time on that. Just to give you the full scope of kind of what's going on with that property.
Yeah, and I agree with you. I would like to have that conversation. I may have the email you're referring to, but we might as well be on the same page. And I think the issue is that they're wanting to make sure that, you know, if they're going to produce new documentation, that they don't have something from their previous work that could meet that requirement. But I know, based on my conversations with the county, that they need to produce a new plan.
Correct, and it depends on how much fill they've brought in, how far that fill goes into, and potentially affected wetlands. Because of where the property is located on the econ, there's a lot that goes into what they've done.
Right.
So the impacts are slightly different than if this was a regular piece of property.
And one question for you, if I could. When you say it needs to be approved prior to, like that's almost like a sufficiency review requirement that you would have for approval of an issue?
So I don't want to say we're treating this like a commercial project, but we almost are, because this has gone so far past a typical single-family residence because of the scope of what they've done on the property. And there's so many various structures that are already on site. We're kind of treating it like a comprehensive review instead of individual. So we're going to take it as a full site plan so that they have it for all the structures, so that they can get one site plan and try to get it all approved as much as we can. There may be some things that cannot be approved with this, and then they can come in for their single-family residence, potentially the dock, potentially the accessory structures, because they've got a pergola, they've got the connex structures, they have all these other accessory things on the property as well that we're not even dealing with yet. We're
Correct.
focused solely on the single-family residence, but they have all these accessory structures that we're not even at the point of dealing with yet.
So I guess my practical concern, well, not concern, but question is, do I just submit this, would they submit the site plan through any application, or just?
That's on the letter. That's why I think
Okay.
getting you this piece of information
Yep.
is so crucial. And then maybe you sitting down with the team that initially sat down, once you have time to digest it, and getting further information if you have questions, or getting you to those key people might better assist you getting them
Yeah,
with their design professionals to get those documents drafted.
yeah, and yeah, I agree with you. I don't want to take up any more hearing time, and I really do want to say that I appreciate the time that you and the rest of the county folks have put into this.
Absolutely.
Okay, Mr. Pike, if this site plan, does this site plan have to be engineered? Is this something that they could draft themselves?
Well, this is a site plan for planning and zoning.
Right.
As far as building, we just need to see where the structures are on site for inspection purposes. And planning and zoning has had meetings. We've had several meetings with these people for a long time now. We still have nothing.
But
We've had
could,
planning and zoning involved in all these meetings. They've been directed on what to do.
and
we
could
have
the,
nothing.
what planning and zoning needs, I understand that they need the site plans and stuff, but it sounded to me like Megan was saying, in order for them to get a building permit from you, this site plan has to be in place. But if it's just that you need something different that has the buildings located, and then the site plan process has to occur too, I understand
Okay.
that.
Okay. To get a permit, everybody has to sign off on it. That is building,
Okay.
engineering, planning and zoning, addressing, and if it's commercial, fire would have to review it. But that is what it takes to get a permit. So when we say they need a site plan, they have to go through planning and zoning to get their site plan approval before we can issue a building permit. We look at a site plan when we do our review just to see where the structures are located on site, how close it is to a property line, stuff like that, to make sure that it meets building code compliance. The planning and zoning review encompasses site, what's on site, what has happened to the site, currently there on site now. And they've done a lot of things there without any approvals or anything. So, and we've had several meetings dating back last year. Nothing has happened. That's the urgency here. They need to get this done. And we're wasting everybody's time.
And that continues to be my concern. When we started this, we gave the 6 months because they were going to, and I recall, they were going to get the site plan in, and they wanted everything being running together, and they had asked that this, all the building permit stuff get moved to where everything was running in conjunction with one another because they were going to do all these things, and they haven't. So that's where my concern lies, that if I continue to let this go on, it does continue to waste everyone's time.
And I completely understand that. That's why I didn't get before you right now and say, we need 6 months. Can you give it 6 months? I think at this point, you need to see progress sooner than it's realistic to expect it to be finalized. So that's why I would offer some sort of check-in time, and I would aim to be back before you with a building permit submitted and issued, hopefully.
So just to clarify, the site plan, to go through the site plan would expedite the review period for the building permit, drainage, natural resource review, zoning review. That's the process of getting the site plan through planning, because there's so many layers with the drainage review, the impacts to the wetlands and the setbacks. Because of the scope of what they've done is so past typical, and it's been over so many years. This goes back to, I want to say 2016, 2017 is when the impacts started. So we're now talking a scope of 8 years almost.
But were they the owners back then?
They were, ma'am.
Okay.
So a span of 8 years that these changes have occurred little bit by little bit by little bit. So when you talk about arbor changes, drainage flow changes, impacts to wetland structures being erected, the pavers, minute changes over time make a huge impact when you're talking about property that is along a protected area like the econ. So that's why we're now requiring this site plan, so that all of the specialists, and it may not even, that site plan probably won't even be reviewed by me, it'll be assigned to a planner, not a project coordinator for review. So someone who specializes in that will actually take that on for review. So by the time it gets to me, I'll be able to go, yep, the setbacks match, everything's been approved, boom, I'm done, my review's done. I won't even have to waste my time on it.
When was the email given to them that?
December 19th of 2023, outlining exactly what they needed to submit for their site plan. And the process by which they would need to submit the documentation once they obtain their site plan to get their building permit issued.
And it's now no longer a concern, but what took up a lot of my time prior to the break between our hearings earlier this year and last month's was, of course, the most pressing issue of getting items off the property, moving pavers that had not been installed, moving the extra items, removing the storage violation that was open that took up their time. And then, relocating their living situation was, of course, another burden on them in terms of working things out and delayed them. And none of that's to say that's the county's fault. None of it is. But they've been preoccupied with other concerns. But they are, since speaking with Mr. Pike on the 13th or the 12th, they have a clearer picture of what this process looks like, and they have been focusing on getting what they need to get together. And I'll take a look at the email that was provided to them at the end of last year and make sure that what they're working on is consistent with those requirements. But they are focused on getting this building permit submitted.
So, and I'm assuming that the site plan deals with, I know we only have 2367 CESM in front of us right now, but it basically is the same. It helps us to accommodate both of these cases that are hanging out there.
So it would address all of the outstanding issues as it relates to all of the structures, the fill, the arbor permit that hasn't currently been pursued, that's hanging out there, and we haven't pursued it because we've had the other cases in place that we haven't felt the need to pursue currently.
But that's not in front of me.
It is not in
Okay.
front of you currently,
Okay.
ma'am. So it would address all of the structures, the fill, the arbor permits, the single-family residence. It should resolve all of the outstanding issues so long as they continue to work towards permitting all the structures, because currently we're dealing with we keep talking about the single-family residence, but they still have all of the Connex containers, the pergola, all of the other accessory structures that we're not really addressing, because the biggest thing is they can't have any of that.
Well, they are. They're in the next case.
They're in the next case, but we keep going, you can't have any of it until you have your single-family residence, because all of it is contingent on them getting the single-family residence permit issued.
So they're trying to get it all done at once.
So they're trying to get it all done at once.
So here's what I'm going to do. It seems to me the only thing that lit a fire was at the last hearing when I said, if you don't let Mr. Pike on the property, your fines are going to go retroactive back to, I believe, July. No, the date even before that. Actually, that they would be imposed beginning on July 11th. So what I'm going to do is I'm going to give them 30 days to get a site plan. They've had since December, and so I'm going to order that they submit their site plan within 30 days. If they do not, and the old order is still in effect, I will also extend, consistent with the site plan requirement, that the case is extended for 30 more days. The building permit case is extended for 30 more days. If they do not turn in a site plan that is completed with all county comments so that the county is reviewing it, by the September 11th, that fines are going to be imposed retroactive back to July 11th. And I think that we are $250 a day in this case.
It ain't going to happen. It's going to
Okay.
take a lot longer than that. If they haven't gotten the proceedings started by now, it ain't going to happen. I'm just telling you. There's
Because
no way we'll get that site plan issued in 30 days.
not
There's
issued.
going to be comments. Each reviewer is going to have comments. You got engineering review, you got planning and zoning review, they've got multiple structures out there. They've moved dirt into the wetland areas. I think they had put a boat dock out there and a walkway out there. Those are all wetlands. That's going to take some time to get this site plan. That's why we've been on them, meeting with them since at least a year ago, and nothing's happened.
I said that it would be submitted by that time. And I understand that the county wouldn't be able
It's going to take
to.
months to get this site plan approved because of the layers that are involved in what they've done out there. I'm just trying to be honest with you.
I do appreciate Mr. Pike being straightforward with us about the scope of and again, I need to review the email that was sent and get a sense for what the scope of what the county needs is. So I can't exactly say what a reasonable timeframe would be on submittal. I understand, Your Honor, what you're trying to say is that we don't need to have addressed all comments within 30 days, but rather past essentially sufficiency review.
No, I was saying that you needed to be able to, it passed a sufficiency review to where they're, to the point where Ms. Zanorski is reviewing doing her final, stamp of approval that she suggested.
Perhaps a reasonable halfway point would be that if we met again in another month to discuss this.
No, I'm not going to do that. That's what I'm trying to avoid. I'm trying to avoid coming back here again with, well, this time they really have been convinced. Because I thought they would have been convinced the couple run-ins that they had with me, but they've stopped showing up. And I appreciate that. That's their right. They can send you as their representative, and I'm completely fine with that. But I'm trying to avoid the back and forth. I was trying to accept that Ms. Zanorski had said that, look, if they do it exactly how it's laid out in that letter from December, then it is literally a rubber stamp from her part. So that to me means that it would be submitted tomorrow, so that you've got the next 29 days to work out any back and forth that they have. So that's kind of what I was hoping for in the 30 days that I was trying to give. So it didn't mean that they had 30 days to submit and wait for comments. It meant I wanted it to be perfect by the time that we were back here, so that these individuals were able to testify to me that, yeah, we're on our way to get a building permit because they have their site plan approval from zoning. Not that, and maybe it's that Megan says, yes, we've had it, and we've had it for 5 days, and we're all finalizing everything or whatever. And I'm saying her part, the rubber stamp part,
Right.
She's had for 5 days. That's what I'm looking for. So they should have already hired whoever they need to hire. It's my understanding that he's got some skills of his own, whatever that is, but this is my last time of
Understood.
giving an extension.
Understood.
And so it's 30 days, because what's before me is a building permit. So it's a 30-day extension on the building permit, which is September 11th. But obviously, they've got to get the site plan done in that. It's got to be done. Because if they come back here and there's not a site plan that has been submitted to the county and not the day before the 11th, then I'm going to impose fines retroactively back to July 11th.
I understand.
Okay?
I understand.
All right. And I'm going to go ahead and open 2417 CESM, Efrain Lima and Kelly Andres. I don't believe that the testimony is different for this case at all. I'm going to, based on the testimony that's already been given, I'm going to also give 30 days in that case, or November 11th, to come into compliance. September 11th. All that's before me is the building permit, so that's all I can continue, but that's with the understanding that a site plan approval would be in place. I'm also going to, in that case, the fines, if not, the fines will be instituted retroactive back to July 11th, 2024. Okay?
Understood.
Thank you.
Thank you.
Okay, let's talk about that after. Good Lord. Okay. I'm going to call 2443 CESM, Wolfram and Megan Nottingdale, Noggle, thank you. Sir, if you'll go ahead and raise your right hand, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2443 CESM. It's for the property located at 2020 Forest Drive, Sanford, owned by Wolfram and Megan Nathaniel. The violation charged Seminole County Code, Chapter 40, Appendix A, 105.1. Description of violation is installation of a shed without the required permit. The initial inspection was done 9/15/23. A notice was given 9/18/23. They've been given several compliance dates and extensions, and we've been out there for inspections on site and via the computer, and the violation still remains on the property. This shows that they are the owners of record from the property appraiser's website. This is the notice of hearing that I personally gave to Wolfram. And here are some pictures of the shed in the backyard. Several pictures. And I believe it's my understanding that he thought it was all taken care of, but it's still outstanding. So I'll let him speak to that here in a minute. This shows that there were no permits for the shed. This is the code section that was cited for unpermitted construction. Recommendation, based on the testimony and evidence presented in case number 2443 CESM, it is determined that the respondents are the owner of record of the property located at 220 Forest Drive, Sanford, in possession and control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, 105.1. I further recommend that the special magistrate Order the respondent correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall obtain required permits for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondents must contact the inspector to verify compliance. I have given a copy of this presentation to the clerk and request that it be entered into the record. This concludes my presentation.
Do you have any objection to the electronic case file that's in front of you being submitted into the record?
No.
Okay, I'll accept the electronic case file. Do you have anything you'd like to add?
Nothing to add, really, just some context around it. I did have a couple of violations from September last year, so I was kind of slowly going through them. I got most of them done. A lot of this was pre-purchase of my property, so the shed, the fence, they all existed before I purchased the property, so they're all there before. But I got most of the permits, and I got it permitted in January. So the last notice I got was in October. So when I finished most of the work, I thought maybe that in good faith, we had dropped some of those violations just because I got the bulk of them done. But then I didn't get another notice. The next notice I got was for this hearing in July. So 7 months went by and I never heard anything, so I kind of assumed that that last shed permit was maybe dropped. But I'm not opposed to fixing it. I just didn't know that it was still open and I was still in violation. So.
Okay, so the county has indicated that they're willing to give you till October 9th. I'm going to go ahead and order that you come into compliance by October 9th. And if not, I'm going to impose a fine of $100 a day for each and every day that the violation remains.
Works for me.
Thank you.
Yep.
Yeah, that. Because I like to check to see whether it's homesteaded or not. Okay, that one's homesteaded, so. Well, I like to see them so I can check to see whether they're homesteaded, because that makes a difference for what I order. Is she back? Okay.
No, I don't have it. It should be in there.
Second one, she's here, okay. 2440 CSM, Rebecca Wiggins.
present his case, and then you can respond to it. This is a copy of
Mrs. Wiggins, if you'll go ahead and raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2440 CESM. Okay. Jason Rucker, Seminole County Inspector. Case number 2440 CESM is for the property located at 1217 Gale Street in Apopka, which is owned by Rebecca A. Wiggins. The violation charge is Seminole County Code, Chapter 40, Appendix A, Section 105.1. The violation is installation of a carport without the required permit. The initial inspection was done 7/14/23. Notice to the respondent was done 7/14/23. There were several extensions and several inspections, along with computer inspections, and the violation remains on the property. This shows that Ms. Wiggins is the owner of record of the property from the property appraisers. We posted the property, and we also got a green card back. Here are some pictures of the carport in question. Several pictures there. And this is the copy of the web picture of the permits that have not been applied for. She only has a solar and a re-roof. No permit for carport. This is the code section that was cited. Based on the testimony and evidence presented in case number 2440 CESM, it is determined that the respondent is the owner of record of the property located at 1217 Gale Street in Apopka, Seminole County, in possession and control of the property and in violation of Seminole County Code Chapter 40, Appendix A, Section 105.1. I further recommend that the special magistrate order the respondent to correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall obtain the required permit for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request that it be entered into the record. This concludes my presentation.
Ms. Wiggins, do you have any objection to the electronic case file that's been presented here that's in front of you being entered into evidence?
My problem is I've had,
Ma'am, first, let's address the evidence. The information that's in front of you, this packet that you were given, do you have any objection to me accepting it into evidence?
no,
Okay, it will be accepted into evidence. Now, please go forward.
okay. Back in 2013, I had that built by a company. And I can't remember the name of the company, and they should have gotten a permit. I had no idea until just within the last year. So I didn't know what to do.
Okay. Well, the county is asking that you get the permit for the structure by October 9th, and if you contact Jason, he will absolutely let you know what needs to be done in order to do that, but you'll have to apply for the permit, go through the process that they need you to go through to get the permit.
Okay,
Because it has to have a permit, even though the company who installed it should have done the permitting for you. They did not. So you'll have to go after the fact to get that taken care of. And it doesn't necessarily have to be by the company who installed it. You'll just have to find someone who is willing to do the permitting for you.
I would have to go to a company to do that? I don't know.
She can do an owner builder.
She can do it in, okay, so Jason will definitely walk you through the
Sure.
process to help you with that. It may be as simple as you doing it yourself. I don't know if, plans are involved or anything, but to the extent that they are, then you might need someone to help you. But he can help you through the process and let you know everything that needs to occur. So they've asked that you comply by October 9th, 2024. So I'm going to order that, and if you do not come into compliance by October 9th, then a fine in the amount of $50 a day will be imposed, okay?
Okay. Do you know how much it would cost to get the order for it? I have no idea.
I don't know.
Do you know the cost of the building permit itself, the application?
Yeah, she can get an estimate at the front counter.
Okay.
She wants to go over there.
Okay, so if you want to go to the building department right now, you could go speak with someone, and they could help you and give you an estimate of the cost.
Thank you, Your Honor.
Thank you. Next case, 2444 CESM. And that's James and Alexander Moser Barker. If I can go ahead and get you both pleased to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Jason Rucker, Inspector for Seminole County. This is case number 2444 CESM. Is for the property located at 2843 Orna Way in Apopka, which is owned by James and Alexander Moser Baker. The violation charged is Seminole County Code, Chapter 40, Appendix A, 105.1, for the installation of a white vinyl fence without the required permit. The initial inspection was done on 10/11/23. A notice to the respondents were 10/11/23 and 10/27/23. There have been several extensions given. There have been follow-up inspections on-site and via the computer, and the violation remains on the property. This shows that they are the owners of record per the property appraiser. The property was posted for the hearing, and here are the pictures of the fence that's installed. Okay, this shows that there is a permit for a fence and plan check, and that was, okay. This screen shows a permit application was received on 8/6/24 to correct the violation. The application has not yet been issued due to requiring pre-screen and planning review. This shows the copy of the county code that was cited. Based on the testimony and evidence presented in the case 2444 CESM, it is determined that the respondents are the owners of record of the property located at 2843 Orna Way in Apopka, Seminole County, in possession and control of the property, and in violation of the Seminole County Code, Chapter 40, Appendix A, Section 105.1. Further recommend the special magistrate order the respondents to correct the violation on or before October 9th, 2024. In order to correct the violation, the respondents shall obtain required permits for the cited violation. If the respondents do not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondents must contact the inspector to verify compliance. I have presented a copy of this to the clerk, and would ask that this be entered into the record. This concludes my presentation.
Hello.
Hi. Do you have any objection to the electronic case file that has been shown and is before you being submitted into the record?
No.
Okay. You can go ahead.
So the biggest issue is we trusted our contractor who we hired to do it. He told us originally that because we already had a fence and it was going in the same place, that we didn't need to worry about a permit. As soon as we got the violation, we contacted him. He told us repeatedly that it was being taken care of. Now, up until we got this, the orange violation in the yard, we had thought it was done because he told us 6 months plus ago that it had been done. I never asked for proof of it because I thought that, well, you are a company, you said that you're handling it, and it's done. So we contacted him as soon as we got home from vacation, after we saw this. He said that he hired someone to get the permit, which I did call yesterday, and I was told that there was something filed, but the application is blank. And so I'm waiting to find out what exactly I need to tell him or a checklist. There is a language barrier when we talk to him, so he goes through a translator or I talk to someone else. So we definitely want to get this squared away.
When was the fence installed?
Last October.
All right. So the county is asking for you to come into compliance by obtaining your permits by October 9th.
Okay.
So I'm going to find, based on what you've indicated to me and the fact that something has at least been filed effective yesterday, that compliance by October 9th is certainly achievable. So I'm going to find, since you did contact the county as soon as you received the notice, I'm going to ask that you come into compliance by October 9th, or you will have a fine of $50 a day imposed for each and every day thereafter that the violation remains.
Okay.
Thank you. And the next case, 2445 CESM, Roger Vega and Catherine Esposito.
Anybody speak Spanish?
Do we have anyone that speaks Spanish? Okay. If you'll take a seat, we'll call your case next. We're going to go ahead and call another case first while we get you an interpreter.
Yo traje a él.
Can you
Yes, I can swear you in. Absolutely. Okay. Okay. And and your name, sir?
I'm Jamie Rodriguez.
Okay. And then, is this Mr. Vega?
Sí.
Yes.
Okay. Okay, I'm going to go ahead and swear you in first.
Okay.
Do you solemnly swear that you will translate from English to Spanish and Spanish to English to the best of your ability?
Yes.
Thank you. Okay, now we're going to swear Mr. Vega in. If you would ask him to raise his right hand, please.
Levante la mano derecha.
Do you solemnly swear or affirm
Si jura que...
Sí.
Yes.
that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Que vas a decir la verdad, solamente la verdad del testimonio que te van a presentar.
Sí.
Okay.
Yes.
Jason Rucker, Seminole County Inspector. This is case number 2445 CESM. Is for the property located at 574 Ruby Court. The violation charge is Seminole County Code, Appendix A, Section 105-1. The description of the violation is extensive exterior and interior renovations, including but not limited to electric, plumbing, HVAC, bathroom renovation, pool renovation to include a spa and pool, pool screen, and additional building structures on the property without the required permits. The initial inspection was done 8/11 of '23. The notice to the respondent was 8/28 of '23. They were given several compliance dates and extensions, follow-up inspections via computer and going out on site. The violation still remains on the property. This shows that Robert Vega and Kathleen Espinedo is the owner of record per the property appraisers. This shows where we posted the property. Here are some pictures of the property. There are a couple aerial photographs that show the structures in the rear and the pool. Aerial photos of accessory structures, new pool enclosure, addition, and enclosed carports. This screen shows an application for the addition was received on 2/5/24 to correct the violation. The application is currently under review and has not been issued. A vacate is being pursued by the homeowner. Comments from planning and zoning were provided to the applicant under the permit application 24-1552. Permit 23-18-412 for the windows and doors is issued, now expired, needs renewed and inspected. Permit 23-18-327 for a fence is issued but needs inspection. It was part of the original violation. This is a screenshot of the application. And these are the notes from the application from Planning Development to vacate. Vacate application was submitted on 10/31 of '23. Vacate is currently under second review cycle. Comments are due back 8/14/24. The next slide shows a copy of the Seminole County Code. Recommendation based on the testimony and evidence presented in case number 2445 CESM, it is determined that the respondents are the owner of the record of the property at 574 Ruby Court, in possession and control of the property and in violation of the Seminole County Code, Chapter 40, Appendix A, 105.1. I further recommend Special Magistrate order the respondent to correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall obtain acquired permits for the cited violations. If the respondent does not comply with the order, A fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request that this copy of this presentation be submitted into record. This concludes my presentation.
Did Mr. Vega understand what was being said?
¿Entendiste lo que estaban diciendo?
Sí, he entendido un poco.
Yes, he understood.
Okay. Do you have any objection to the electronic case file that was shown being submitted into the record?
Que si tienen alguna objeción, que pongan esto en los records. Sí o no. Que no tengan objeción, sí o no. Que pongan esto como pruebas. No. No.
Okay, it will be accepted into the record. Jason, let me ask you a question. You had indicated that there is a request for a vacation of an easement in process that was filed in November of last year.
Was October 31st of '23.
Okay, so it's my understanding, is my understanding correct that he wouldn't be able to get planning approval for the building permit to go forward if he did not have this vacation completed, or if the vacation?
On certain items, I believe. That would just be for certain items. Interior remodel, he could get permits for.
Are they all separate permits?
They can be. I would think that the exterior structures would have to be separate.
So if I build a house, I have separate permits for exterior than interior?
No, the separate permits would be for like an accessory structure, shed, carport,
Okay,
such of that nature.
okay.
Interior, the house interior could be a different permit. The pool would be a different permit.
Okay. And can we go to the aerial for a moment? So that T-shaped structure was added on without a permit?
Yeah, because you see that was before, and then that was after.
Sure. I just reviewed this.
Okay.
Good afternoon, ma'am. Megan Zanorski. So I actually just reviewed this permit earlier today, so I have a really good handle on kind of where the status of where this is. So this structure has a multitude of additions and conversions on it. So the portion on the front that looks like a garage was a garage that was converted to living space. The rear had a porch and an addition added onto it as well. And then in the rear, there's a separate that looked like it was a shed that was converted to living area, and a portion of the wall and the fence and the shed / now they're calling a mother-in-law suite. That's a part of what is in the easement that needs to be vacated. The vacate is still in process.
Can you tell me where on the property the easement is?
The easement is along the rear of the property, so back by the pool cage and in the rear where the shed is. So the interior renovations and the additions, and I believe the fence permit has been issued. So the fence permit's been resolved, but the addition, I believe, correct? The fence has been resolved?
It's just expired, but yeah.
It's expired, but it's been, the fence is okay.
The fence is okay even though it's in?
So it was issued, I don't think they ever got their inspections or they didn't pay for it, but it was approved. I did approve the fence, they just haven't finished getting their inspections or paying for it.
The back fence?
So they can have a fence in an easement because we require an estoppel letter.
Okay.
So if they need to have access to it and it's not vacated, and the county is takes the stance that they vacate the minimum possible to accommodate whatever the encroachment is into the easement, if the easement or the vacate is even possible.
Okay.
So this structure, I don't believe the structure at all was ever permitted, and it encroaches entirely into the easement, so I don't even know if the easement vacate is going to be possible. I don't know the status of the vacate. I did not check on the status of the vacate. So I don't even know if they've turned in all their documentation on the vacate. But and they've lumped all of it together. So they haven't attempted to permit the mother-in-law suite conversion with the shed separately from the conversions on the main structure. So they could choose to permit the accessory structure separate from the main house, because the main house could potentially be issued separately.
Okay. Are you understanding what's being said?
¿Entienden lo que están diciendo? No, so...
Could you please take a moment to explain it to him?
Hay un par de cosas que están pasando. El permiso de la verja ya te lo habían aprobado, pero nunca se pagó. Eso lo tengo que entrar. Y el permiso que se aplicó de todos los cambios que se hicieron, ellos lo pusieron como un permiso todo junto. Ellos quieren separar. O sea, para la casa y otro para el apartamento. So I explained to him what you guys want to do, separating permits and...
Well, and I'm not entirely sure, and you would need to look at your site plan and your survey, that the new addition that's on the rear, the pool enclosure, and that new addition that goes all the way back, I'm not sure that that doesn't encroach either. So I'm going to defer to your plans.
Okay.
Because if they do encroach, you're going to want to wait until the vacate is complete, because there's no point in separating them if everything encroaches.
So the vacate process is already in place, the permitting, or no?
He's applied. Whether or not he's supplied everything that the planner needs to complete the vacate,
Okay.
I don't know. That's not something that I process.
Okay.
He's welcome to go upstairs to the second floor to check on where that is in the process.
Okay.
But that can take up to 6 months. So I
Okay.
don't know if you want to give him 60 days to come back in to see where because if it's been that he applied for it several months ago, it should be moving through the process by now.
Okay. Yeah, if it was applied for back in October, I'm a little concerned why it is taking till now to be processed.
Okay, so Jason has comments that say vacate is currently under second review cycle. Comments are due back 8/14/24. So next week. So
Right.
it's the second review cycle.
So that means comments have gone to him already? Is that what the second review cycle means?
So it's probably going through all of development review for the various divisions that need to review it: utilities, environmental services, drainage, all of the various people. And then it'll go back to him for comment, if need be, or it may end up being that everybody approves it and it could go to board. So that's up to your purview on how you want, if you want to bring him back in 60 days, because if it's approved, then the vacate would go through the board, it would get approved, he could then provide it, get his new survey, and then it could, or we could give him another 30 days if he still has to wait for it to be.
How long does it take, once the vacate is fully approved, if it's going to go to the board, how long does it take before it's final and approved by the board?
Dale, do you know the tracking time frame on a vacate if it's approved by staff? I'm going to defer to the planning manager.
Okay. Can I swear you in? Thank you. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So it can vary. Usually it takes about a month and a half or so, month and a half to 2 months, because it all depends on the workload and actual volume that's already scheduled for the commission meeting. And so a month, 30 days to 45 days.
Okay, thank you. Is anyone living in this building, this T-shaped building?
¿Hay alguien viviendo en la casa ahora mismo?
Yo vivo en mi casa.
Yeah, he's living in the house.
When I was there and delivered the notice, I handed it to his tenant. So yeah, there's somebody living there.
Okay, and Are you all okay with people living in it with it out?
I don't know how to answer that. You're allowed to do remodel work and still live in a property?
Remodel, yes, they built that entire thing. That was fully new construction.
Yeah, and I'm not sure without plans. I have not been able to get on site to look at it. I've not been in there to see it.
Okay, so what I'm going to do is I'm going to order that you let the inspector on the property to go through it and look through it and see the magnitude of what's on site.
Those plans for the addition, the back addition, the front, and all that, they were turned in to the building department.
That's part of that one permit that's showing?
Yes, the pool, the garage, the back addition, everything that was on the list, it was drawn up, submitted through the building department.
Okay.
And that's like a master room, bathroom, that addition.
Okay,
It would still be good if I could get out there and take a look.
absolutely. So I'm going to order that you make contact and let the building official on the site to see the interior and to see all of the changes that have been done. And I'm going to order that you come into compliance by the next meeting. The county has given you 60 days. Asked for 60 days. I'm actually going to give you 30 because I want to make sure that you let the county on site so that if there's anything dangerous, that we can address it at the next hearing. So I want you to come into compliance, even though I understand that you're likely not going to be able to receive a building permit by September 11th, but I'm going to ask that you come into compliance by September 11th, and in that time, before September 11th, I'm going to order that you let the building official on site, and if you do not come into compliance and do not let the building official come on site, I'm going to impose a fine of $200 per day for each and every day that the violation remains.
And when you see coming to compliance, is letting them go into the house?
Well, the reason that you're here is because there's not a permit. So come into compliance means receiving a building permit. I understand that it's not going to be likely that you'll receive a building permit by September 11th.
Right.
But I want us to be able to come back here on September 12th, which is the hearing date.
Okay.
So that I can make sure that you've allowed the building official in. He can give testimony related to the progress. And so at that time, then we would consider, based on his testimony, how much time you really are going to need to complete the building permits.
And would they contact him to see what day you guys going to come?
I'll give you my card so that we can schedule an appointment.
Okay, and then I could be
Okay.
there with you.
Yeah,
Everything
Yes.
that was drawn up and submitted should match what's
Okay.
there.
Yes.
Sounds good.
Perfect. Okay?
No problem.
You want to go ahead and explain to him?
Ellos van a básicamente no ir a mirar la casa y ver lo que está allá adentro y compararlo con lo que se sometió lo que está ahí. Hay que regresar en septiembre 12 para ver cuánto tiempo más va a necesitar para que aprueben todo.
O sea, ellos no lo van a aprobar ahora mientras que ellos no vayan.
Because before he came, he went upstairs and they told him the permit, the revisions were submitted, and he might be out in next week or so, the building permit.
Okay, great. Then if that's the case and we can get this all taken care of, then maybe you'll be on your way September 11th. But what I'm hearing is that's probably not likely.
It's not.
But I want to make sure that Jason is able to get on the property to be able to assess it so he can give a better assessment of how long it is going to take.
Okay, no problem.
Okay, great. Thank you.
Thank you.
Dale.
Is that your business card?
Yes.
Okay.
You want another one?
Let me get another one.
Okay. Yes. Give me a call and we'll set up a time to come out. All right?
Thank you.
Thank you.
The next case, 2446 CESM Lake Forest, owner LLC. You'll go ahead and raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Thank you.
Jason Rucker, Inspector for Seminole County. This is case number 2446 CESM. Is for the property located at 5433 West State Road 46 in Sanford. Violation charged, Seminole County Code Chapter 40, Appendix A 105.1. The violation is installation of 4 sheds without permits on the property. The initial inspection was done 6/27/23, as well as the notice was given 6/27/23. There have been several compliance dates and extensions given. There have been follow-up inspections on the property and follow-up inspections by the computer, and the violations remain on the property. This does show that Lake Forest Ownership LLC is the owner of the property via Seminole County Property Appraisers. They were given notice, and the next photos show the sheds that are on the property. You can see they all have different dates. We were out there several times. All right. This screen shows the application was received on 11/10/23 to correct the violation. The application is under review and has not been issued as a permit due to required corrections from multiple departments. This screen shot is from E-Plan Workflow. Application 23-17530. The correction text was submitted to the applicant contractor on 2/1/24 and has not yet been completed. Corrections are required from the following departments: building, fire, addressing, drainage, and planning and development. This is the code that was cited, Chapter 40, Appendix A, 105.1. Based on the testimony and evidence presented in case number 2446 CESM, it is determined that the respondent is the record owner of the property located at 5433 West State Road 46 in Sanford, Seminole County, in possession and control of the property and in violation of the Seminole County Code, Chapter 40, Appendix A 105.1. I further recommend that special magistrate order the respondent correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violations. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondents must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request that it be entered into record. This concludes my presentation.
Do you have any objections to the electronic case file that's been presented, that's in front of you, being submitted into the record?
We don't have any objections. We do have updates.
Okay. Thank you.
Well, if I like, I could start with all the details on this valuation. We received a valuation on the sheds. We were not, when company took over the property, we were not aware.
Can you speak directly into the mic? I'm
Sorry.
That's okay.
We were not aware that two of the sheds, the larger ones, never had a permit. They were there when the company took over, and from my understanding, they've been there for over 20 years. Now, the other two sheds are smaller ones.
Number 3 and number 4.
3 and number 4. Originally, we installed those about 3 years ago. Prior to the installation, we actually came down here and asked if we require a permit. They were told us that with the information we provided, since the sheds were 10 by 10, they did not require any permit. One of them is 8 by 10, the other one is 10 by 10. The 8 by 10 is considered a portable shed, and the other one, it's a 10 by 10, which that one I was only told that all you require is that to put it somewhere where it's attached, where it won't come off, which is what we install those little, the platform on that one. But all they asked me for was the information of the sheds. They said that because they were smaller than 10 by 10, they did not require a permit at all. So we never requested a permit for that one, for those two.
So once you got the notice and you were told that they did need permits,
Well, when they told us that we need a permit, that's when I came back and asked about that, and it says like, no, you don't need a permit. You will require to provide on the violation proof of, not proof, but information of the sheds, everything that you have about those two sheds, which we put on a file and provided to them. And then for the other two sheds, the ones that require a permit, then we'd contact the contractor to start up approval permit, which they did. They did an application online, and originally they sent the contractor company 5 requests. The company provided the information for those 5 requests. After those 5 requests that were sent to them, they got another request of another 5. When they submitted those 5, they got more. So it's since the day we opened this case, they're constantly sending to the contractor, obviously not me, they're sending them more information. The contractor, to my understanding, has been providing those information. And every time he does provide this information, they are requesting for more information. We also had to open a second permit for the electrical part, because we were told that since the 2 larger shed have electrical work done on them, then you
Only
require...
1 or 2?
Both of them.
Okay.
They require a permit now for that, which we hired an electrician who opened a permit for that also. And he opened that, I have it here. He'd opened that on August, and since August, he's been working on it until about a month ago that was finally approved.
last August?
Yeah, correct. The
Okay.
electrician has been working on that permit all the way from August, so it did not get approved until a month ago, because again, the same situation. They were giving him 5 requests. He would respond to those 5. Were given another 5, and it was just like that for until last month, where they finally said that everything has been approved for the electrical part. So now, the other contractor has been trying to get I guess the structure part approved. We have sent, the last one was sent about a week ago. On February,
February.
No, they sent a list. On February, they sent a request about 19 comments. And those 19s, I don't have it, those 19s were actually submitted about Monday, to be exact. We received from the engineer the new blueprint, because they were requesting to add all the comments into the blueprint. So the engineer finally got it all completed and sent it on Monday. And now we're just waiting for a response on that.
Okay, so none of that's showing in your permit screen. Are there,
Yeah, there's a permit screen that we,
right, but none of those, there's not showing where there was an electrical permit approved, is there?
yeah.
Which one's the electrical?
Permit issued, the second one down.
Okay, so so it was issued last August,
Yes.
the
That's
electrical.
only for electrical.
Well, you indicated that you were working on it since last August. It got issued in August.
2023.
Yes, you said that you worked on it since last August.
We started, that's when we started the whole process.
It was issued in August of 2023.
According to my electrician, because he was showing me every month, that was not for the shed, then that had to be for a different one.
Right, that was for the electric.
But there was for the shed itself. So there was two different permits. One for we have a house in there that required new electrical work done based on the county, and that was completed on that time.
So is that electrical for their house, or is that for the sheds?
I would have to research that. I thought it was for the sheds.
No,
That is electrical only for the sheds.
So that's when we applied for 831?
Yes, and then the permit for the actual installation of the sheds was not until November of 2023.
correct, because that's when I was able to find a contractor to get involved in that one.
Okay.
I was able to find the electrician first, and then I was able to find a contractor for the other part.
Does the county have any evidence of these back and forth, 5 comments, 19 comments that are being stated?
It would be with the, yeah, it's all on E-plan, so, I mean, we could access the notes. But I do see where in the 23, the electrical permit was applied for.
All I know is
And it was
by
for
my-
the sheds. The electrical permit was for the sheds, 9/22 and 23, 9/22/23.
There's a house on this property? This is a house?
There's a house that sits right in front of the sheds, yes, ma'am.
All right. Originally, the owners of this property, they lived around the assisted living. There was a house next to it, the assisted living, and I guess the owners had a shed. They lived in a separate prior to the building. So when we took over the property, the house and the shed, everything came with the property, with the assisted living property.
There's an assisted living property. That's what's operated on the property.
Correct.
Okay.
Just to clarify, all the sheds need a permit. It doesn't matter what size they are.
Okay.
And you and
Vicki,
came on site, and we did look at them. We had 2 of the smaller sheds that we were concerned were on the easement, and as of yesterday, they were moved. So those should no longer be on the easement, so we can include that in the permit.
All right. One of the requests that was given to us, because she says even if the permit for the sheds are approved, your smaller sheds are on too close to the fence, to the neighbor's fence. So she says that the only way that will get approved is that we move them. So we moved the sheds.
Okay. And I have your name here, Ivan Galeo?
That's correct.
And what's your affiliation?
I'm the maintenance director for the property.
Okay. And Mrs. Cowan, you're the executive director of the?
Correct.
Okay. Okay. The county has recommended that you have until October 9th to come into compliance. I feel like you have been working with the county, especially if you've been there and they've been on site. I can't encourage enough for you to keep up that communication. I think that October 9th is reasonable under the circumstances. And I would just urge you, if you get comments, you've got to respond to the comments, and you've got to give them what they need so that they can process this for you.
That's exactly what we're doing. My concern is that every time we do respond to the comments, we end up getting new ones, so that it's just.
And sometimes that does happen. And
I was hoping that, I was told this is, it's an easy thing, so we follow everything that they ask for, and that's what we just keep doing. Every time we get comments, we submit them for approval.
I think there's a breakdown between their contractor and them and us.
Okay.
So
maybe one of you should be on site when the contractor comes, or maybe you could arrange a meeting with all three of you so that there's not, well, the county told me this, well, the contractor told me this. Then everyone's hearing the same information at the same time. That's definitely going to make the process smoother.
I mean, if it's required for me to contact, because I have multiple people involved in this,
We will schedule a meeting.
But yeah, if we have to get
schedule a meeting
them
with Jason.
all done together with
you
the
can
county.
always contact me. I give you any information you need.
Okay.
What's required, anything for me plan that they write up. I'll
But
give
if
you
it's
that
help-
information so you know, so it's not going secondhand from your contractor.
But if it's helpful to be there presently with everyone, I would definitely set that up. I will contact them, and then we could get all together. That way, we're all on the same page to make sure that there's no miscommunication on the long run.
Perfect. Okay, then I'm going to go ahead and find that you can achieve obtaining your necessary permits by October 9th, and I'm going to impose a fine of $200 a day if for some reason you do not come into compliance by October 9th. And again, I can not urge enough that if you keep up the communication is going to make all the difference.
Okay.
Thank you.
Thank you.
Question, sir. We submitted on Monday. How long, usually, since I don't get the communication with the county communicates with the contractor. When they send something, how long does it usually they get that response?
Go ahead.
So I'm just, can I interject, ma'am? So this permit is in its first review cycle still for this review cycle. So it's a commercial permit. So commercial permits work a little different than residential permits in that it comes into the planner that does it.
I understand.
They get all the comments back and then they give them a ComDoc. So it's not that they're getting piecemeal comments back on this. So if it moved or relocated or something changed, and I'm struggling with this one because it's currently under review, so I don't have a ComDoc to provide to you currently, and I don't want to give them piecemeal documents. So if they want to get the status of this permit as it sits, I suggest they go up to the second floor and talk to their project manager about the status of this project as it is, since it is a commercial permit. And then maybe get the project manager's information so that they can discuss it directly, and maybe get view-only permissions for this project so that they can, with the building department, and then go that way so that they can view what's going on with their permit.
So do we have the card of the project manager, or could we give some contact information to them? We've given them Jason's.
I can give them the planner's name and so that they can go upstairs and
Perfect.
discuss it with her.
That'd be great. Thank you.
Thank you.
Thank you. I'll take another one.
Okay.
2452 CESM Sergio Salazar. Mr. Salazar?
Yes.
If you raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Jason Rucker, Inspector, Seminole County. This is case number 2452 CESM. Is for the property located at 3572 Jericho Drive, Castleberry, owned by Sergio Salazar. Violation charge is Seminole County Code, Chapter 40, Appendix A, Section 105.1. And the violation is installation of a deck in the front of house without the required permits. Initial inspection was done on 11/14/23. Notice to the respondent was issued 11/14/23. There have been several compliance dates and follow-up inspections on-site and via the computer, and the violation remains on the property. This shows that Sergio Salazar is the owner per the property appraiser. The property was posted, and here's some pictures of the deck. There's a previous picture of what it was before, and then there's the new deck that is being redone. This screen shows no permits applied for or issued to correct the violation. Permit 23-15-421 is for the replacement of existing AC, and 21-85-45 is for a fence. This is a copy of the code section that was cited, 105.1. Based on the testimony and evidence presented in case number 2452 CESM, it is determined that the respondent is the owner of record located at 3572 Jericho Drive in Seminole County, in possession and control of the property and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. I further recommend that the special magistrate order the respondent to correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violation. The respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request that it be entered into the record. This concludes my presentation.
Do you have any objection to the electronic case file that's been presented here today that's in front of you being entered into the record?
No.
Okay, I'll accept the same. You go ahead.
So I'm having a hard time finding a contractor that would do the drawings for me without actually doing the work. What we did is originally just replace the deck that was there, was our intent, but then we thought we'd just extend it a little bit. Now we're having a hard time finding somebody to do the CAD files or whatever so I can pull a permit. If I can get more time, hopefully find someone that can do the drawings.
The county has offered that for you to have the permits come into compliance by October 9th.
Okay.
That gives you a couple months. I think that that's probably sufficient.
Yep.
This isn't a major rebuild or anything, so I think that you definitely can achieve compliance by October 9th. And I'm going to, I definitely want you to make sure that you continue to be, this case hasn't been going on as long as some of the others, but each time that the county contacts you, if you will remain in contact with them and you will respond as they ask for things and make sure that you are doing what they ask, I think it's going to say a lot. So if you do not come into compliance by October 9th, I'm going to pose a fine of $100 a day for each and every day thereafter that the violation remains. Thank you.
Thank you.
2455 CESM Maribel and Elsa Mercado Musa. You both raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
I do.
Thank you.
Jason Rucker, Inspector, Seminole County. This is case number 2455 CESM. It's for the property located at 1667 Kingston Road, Longwood, owned by Maribel and Elisa Mercado Musa. The violation charged, Seminole County Code, Chapter 40 of Appendix A 105.1. It was the installation of a metal building without the required permits. The initial inspection was done 10/12/23. Notice to the respondent was issued 10/12/23. There have been several compliance dates and extensions. There have been follow-up inspections on-site and via the computer, and the violation remains on the property. This is the property appraiser's site card showing that they are the owners of record. The property was posted, and they did sign for the green card. This is a picture of the shed in the rear of the property. And it does still remain on the property. This is a screen showing that the permit application was received but has not yet been issued. Permit number 2317519 for metal shed remains in plan check status due to required zoning corrections for the setback. This is a picture of the application. It was submitted. After plan review, plan and development application needs a variance to keep the metal shed in the location it's at. Variance application was submitted on 7/25/24. The variance request is scheduled for the Board of Adjustments 9/23/24 hearing. The next sheet shows the code that was cited, Chapter 40, Appendix A 105.1. Based on the testimony and evidence presented in case number 2455 CESM, it is determined that the respondents are the owner of record located at 1667 Kingston Road, Longwood, Seminole County, in possession and control of the property and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. I further recommend that the Special Magistrate order the respondents to correct the violation on or before October 9th, 2024. In order to correct the violation, the respondents shall obtain the required permits for all the cited violations. If the respondents do not comply with the order, a fine of $50 a day will be imposed for the violation if it continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request it be entered into the record. This concludes my presentation.
Do you have any objection to the electronic case file being submitted into the record?
No, ma'am.
Okay, I'll accept it. You can go ahead.
No, for the record, my name is Dr. Yasser Musa, and I'm the husband of Maribel Mercado.
Okay.
Musa, yeah. So basically, legalities, she's the owner of the property.
Okay.
My question is to the magistrate and to the board, please. As you mentioned and you saw that there was a variance application there, to be clear, is going to be seen at September 23rd, correct? That's what you mentioned? Okay, so by the time the October 9th comes in, if it comes in, then I'll put all the paperwork for you, and that'll be okay, right? In terms of, once the variance goes through, then I can submit the paperwork with you, and then we can figure it out, everything else of the paperwork, correct?
Correct.
Okay. If you can, give me a card of your information, please.
Absolutely.
That way we can keep in contact and, pretty much get this
Yeah,
situation
absolutely.
resolved. Thank you very much.
And the county is confident that everything that needs to be done with respect to the variance can be completed by October 9th?
So there's a 15-day appeal period after the hearing. So if the hearing is on the 24th, the appeal period will not have yet told, I don't believe. 31st. No. So if you want to continue it to November, then it'll give me time for them to have reapplied and me to have approved, reviewed, and issued the permit.
Thank you very much.
Okay.
Appreciate it.
So it appears to me that, this, once again, this case hasn't been going on terribly long. It did start last year, but I see that you have processed a variance application, so that certainly takes a little bit.
Yes, ma'am.
So I appreciate you continuing to communicate with the county at all times. I'm going to go ahead and order compliance by November 13th. And if you do not come into compliance by November 13th, I'm going to impose a fine of $100 a day for each and every day thereafter that the violation remains.
Thank you, ma'am.
Thank
Appreciate
you.
it. Have a blessed day.
Okay. 2277 CESM B&B Land Holding, oh wait, I'm sorry, we did that one. 2332 CESM Melissa and Michael Mitchell.
Is that? Well,
Ma'am, if you'll go ahead and raise your right hand, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2332 CESM. This is for 2916 Quincy Court. Owners are Melissa and Michael Mitchell. This case was originally heard by the Special Magistrate on March 9, 2023. An order was issued giving the respondent's compliance date of April 14, 2023. On April 13, 2023, an order was issued extending the compliance date to July 13, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on July 20th, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on August 6th of 2024. The administrative cost for the inspectors on this was $594.51. The administrative cost for the clerk was $173.98, totaling Total cost of $768.49 for both the inspector and the clerk. Special Magistrate Board issued an order recommend that the Special Magistrate issue an order constituting a lien in the amount of $19,650 for 393 days of noncompliance from July 13th, 2023 through and including August 8th, 2024 at $50 per day, and a fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after August 8th, 2024. That completes my presentation.
Okay. Would you like to address the issue?
Yes. So one thing on here, I think the last time I was here, I mentioned that there was no change to any windows, and that was supposed to be changed. We just, one of the alterations was that the window was taken out, but it was the same window put back in. So there was no alteration with windows.
Okay, we're not here to hear the case again.
Oh, okay. I'm sorry. So after I came in, I actually sent 2 emails to the only person I knew to contact, asking for an extension or asking for something, and I have copies of them too. We were trying to find, and so from the county, this is what I was told, we needed to find a structural engineer to come in and revise the permit that was originally pulled for siding. We didn't pull the right permit because we weren't initially going to change anything else. There was other damage that was found. It's a very long, drawn-out story of termite damage and other things that are not really relevant to this. But we were in a litigation, and so we weren't able to do the structural changes or anything for a while until our HOA decided to try to sue us. So we had to pull the trigger and get a contractor out immediately, and I honestly did not think to fix the permit. It just didn't cross my mind. I explained this before, so that's how we got to where we are now. I want to fix it. I would love, I tried to reach out. I even called this number when I got this because I had not gotten any other communications from anyone since I was here last. This is the first time I got anything. So I called, I left a message, and never got a call back. So I really would like to fix the issue. It's just more complicated than just going in and revising a permit, because getting a structural engineer to come out, I can't find one. I've talked to, sorry. Sorry, I'm not trying to be an idiot. So I've talked to multiple people, and I can't find somebody to do what you guys need me to do. And so I'm kind of at a point where I would like to fix the issue, but I don't know what to do.
So I'm looking at the permit screen. If you could go to the permit screen, I'm not seeing where a permit was pulled. Like, I see a permit from 19 that was issued. Is that the permit?
Yeah, that was the initial permit. That's when we initially found damage, and then obviously COVID happened. We were in a lawsuit. The lawsuit literally just got closed out like a month ago. I mean, this has been like an ongoing thing for a long time. So the initial work was only to be done with siding. So there was just other things that were found underneath the one side that needed to be fixed. And like I said, I just I didn't think to go in and revise it.
Okay, but the problem I have with it is that you didn't contact the county after you came before the magistrate. Obviously, it was the different magistrate from myself. You came and asked for special request to get an extension to the 13th of July last year, which I'm assuming is when you discovered some of these issues. And so that was granted to you, and then you did nothing.
No, I reached out twice. I have 2 emails that I never got responses from, and then I also called. And then I didn't know what else to do. I was,
And you had those emails with you?
yeah.
Okay, if I could see those emails.
And I don't know if it was just a different person or if I didn't get an out of office or anything. I didn't get a bounce back. And then I got no other communication. So I just didn't know what to do. And I kept looking it up online to try and see if there was something I could do, but I didn't know. So.
So once you did not receive a response from Ms. Hughes on June 12th and July 13th, you didn't make any additional attempts?
I've called a couple of times, but I didn't know who to reach out to. There was no, the person that initially cited the code was not there anymore. That was the other contact I had. And then, I work full-time, I'm busy, it was like out of sight, out of mind, and it wasn't something that was intentional. But finding a person to fix it properly has been a huge challenge. I have got some people that I've called, but
Those in the file.
because I need to have an engineer do it. Yeah.
Those into the record.
Yeah. If anybody has any suggestions, I'm open. I don't know what to do.
And the additional work that was completed, do we know exactly what it is? Or because what I have, the original order was exterior alterations, sheathing, windows, and framing. Is that all that was done? That is the exterior alterations, including the sheathing, the windows, the framing without the required permits? And that requires some structural engineering? Have we given comments to that effect?
Yeah, I am unaware of that. I don't know what the structural comments would be for, other than if it got an inspection or if an inspector went out there and saw something that wasn't on the original permit application requiring something additional.
Would you have notes of that?
The one that starts with Brent. Brent saw the exterior alterations during his re-roof inspection.
Brent, yeah, it says that one of our inspectors saw the exterior renovation and construction at this address above when he was doing a re-roof inspection.
This is just.
A re-roof inspection at this same address? And then that was, so you, in the meantime?
It was the next door neighbor. I think he was inspecting and he saw that there was work being done and the permit was not the right permit. I know the work that was done. I would revise it, but I was told that I can't from code. They said that it has to be a structural engineer and I need blueprints and I need them to put a seal on it, and there's a lot that goes into that. And it's a lot of finding it just a structural engineer to even call me back has been really challenging. And then when I do get somebody on the phone, they won't do it. So I don't know what, I'm kind of in a, bad place.
Did you pull this one for me?
Her lawsuit and prohibiting her from getting permits.
Jason, do you have any idea how long it would take her to get a permit?
Well, if there is structural engineering that's required, for whatever it is that they did, unless, was there termites in the wall or something? You had to redo the exterior wall?
It was just damage on some of the boards, like the framing.
Okay.
And it was, the insulation was all replaced, and then the outside sheathing was replaced as well on that wall. So it wasn't, nothing was changed structurally. Like, it's the same layout, it's the survey, wherever it was already built. They just replaced some of the damaged wood. So it wasn't a complete reconstruction or anything like that.
I think probably what happened was that some of the structural members, sounds like it was a wood frame structure, and some of the major components probably got damaged and were replaced, which we would need to see. Yes, there will probably have to be a structural engineer come out there and make a determination and how to fix it, and then once she gets that done, submit that for the permit, to complete the permit, to be able to have it inspected.
And my concern is that the case lay dormant for so long. So, and had maybe we been able to explain this to her, a while ago when this was supposed to come into compliance, maybe we could have had some, movement by now. What do you think is reasonable as far as being able to get a structural engineer to handle this and,
typically getting an engineer, it all boils down to money. So they should be able to find one, should be able to do one, but it depends on how much it's going to cost.
do you want to?
For the record, Bob Pike, building official, Seminole County. She can certainly take over the permit herself if she's having problems. She could do an owner-builder permit. She can certainly open up the walls for us to have us to take a look at it. We can make a determination at that point. If it's like for like, we probably wouldn't need an engineer. I recommend that maybe I can have my chief building inspector meet her on site and give her some advice.
Okay.
We can't do the job for her. We can't tell her what to do, but we can certainly look at it and give some fruitful advice.
Okay.
And we'd be more than willing to help her do that.
Okay.
But it's going to take a little bit of time, depending upon the extent of the work that was done.
Okay. So I'd like to just give you the 60 days then to the October 9th, because I want to make sure that you do this, and I'm going to order that you allow the building official to come into your home and show them what they need to see in order to assist you with this. And let's come back here on October 9th. And as long as you're continuing to communicate with them, then I don't see a problem. But the moment that the communication stops and we have such a gap again, I'm going to take an issue with that. So I will go ahead and give a continuance of the compliance date to October 9th, and everything else in the original order will remain intact. So the $50 a day will still be the fine that is imposed if you do not come into compliance. And I will let you know that if you don't continue to communicate with them and come into compliance, we at some point would find ourselves where we're retroactive. We'll retroactive the fine back, and right now it's at $19,000 plus.
Right.
So I encourage you to get with the building official as quickly as you possibly can.
Yes, of course. Yeah,
Okay.
thank you.
Thank you. 2361 CESM, Sandra France. You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2361, CESM, Sandra France, 700 East Osceola Road, Geneva. This case was originally heard by the Special Magistrate on September 14th, 2023. An order was issued giving the respondent a compliance date of November 17th, 2023, with the meeting scheduled for December 14th, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on November 27th, 2023. On December 14th, 2023, an order was issued extending the compliance date to March 13th, 2024, with a meeting scheduled for March 14th, 2024. An affidavit of noncompliance was filed by the inspector after reinspection on March 13th, 2024. On March 14th, 2024, an order was issued extending the compliance date to August 7th, 2024, with the meeting date scheduled for today, August 8th, 2024. An affidavit of noncompliance was filed by the inspector after reinspection on August 6th, 2024. Administrative costs for the clerk were $181.26. The administrative cost for the inspector was $820.16, for a total of $1,001.42 for both the clerk and the inspector. Recommendation is that the magistrate issue an order imposing administrative cost totaling $1,001.42 and require the cost be paid within 30 days. Or a fine will continue constituting a lien on the property. I met with Ms. France when I was out there on the 6th, and she has had some issues and some different personal things that have come up. And she has removed a couple of the structures that are out there, and she's in the middle of getting one removed. And I think some of the issues are that there's lack of help there as well. So that completes my presentation.
Okay, and so how many structures remain?
Go ahead.
The one.
Just one structure?
Just
And
the pole
what-
barn, yes.
Are you planning on removing the pole barn?
No, I have someone that is giving me prints. He finished that. He's just waiting for them to get sealed. And it's been 2 weeks. I've been in contact with him, and he still hasn't gotten them back yet.
And so no permits have even been submitted for?
No, like I said, I was waiting for the prints.
Okay.
She had a death in the family, so it's been hard.
Okay.
Yes, Your Honor.
Yes.
Her husband was the one handling all this, and he passed away.
Okay.
So she's been left to try to figure out how to get everything done. Everything is being done. It's just taken time because the person that has those plans that were required hasn't got them back yet with a seal on it to be able to be submitted. And this is all stuff she's been having to take care of where she didn't know anything about how to do it before her husband passed away.
Okay. So how long do you think that it will take her to?
He's already got the plans done?
He's got them done. He's just waiting for the seal to be approved.
And we don't know for sure how long that's taking because he hasn't told us.
Yeah. It's been 2 weeks. I've been in contact with him, but he says he hadn't gotten them back yet.
So you think October 9th is possible?
I would say probably give her a little bit more time than that.
Okay, so, the next hearing after that would be the November 13th, the 14th hearing. You think November 13th? Okay. Then we will go ahead and issue a continuance to November 13th, which is the day before the next hearing, to hopefully be able to come into compliance. Okay?
Okay.
Thank you.
Thank you, Your Honor.
Hit computer. Don't share it. Just hit computer next to the yellow button. No, not that.
2407 CESM, Amanda and Christopher Yeager. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2407, CESM, Amanda and Christopher Yeager. Location is 1480 Mirkwood Cove, Oviedo. This case was originally heard by Special Magistrate on March 14, 2024, and an order was issued giving the respondents a compliance date of August 7, 2024, with a meeting scheduled August 8, 2024. An affidavit of noncompliance was filed by the inspector after reinspection on August 6, 2024. Administrative costs for the inspector total $661.46. The administrative cost for the clerk was $87.37, totaling $748.83 for both the inspector and the clerk. Recommendation is asking the Special Magistrate to issue an order imposing a total of $748.83 and require this cost to be paid within 30 days or a fine will constitute in a lien to the property. This concludes my presentation.
So is the property in compliance at this time?
No, non-compliance.
Okay.
An affidavit was issued of non-compliance on August 6th.
So then you want the fines to be imposed at this time, not just costs?
Yes.
Okay.
We had to get a wetland study done in order to figure out if this was on a wetland delineation. It took me a couple of months to get Dr. Storm Richards to a place where he could come out and do that. So he did that in the beginning of June, and I got a new survey drawn up along with that. And I had emailed Sarah Wartung and Vicki Hathaway shortly after that, both the survey and the wetlands delineation. And at that time, was notified that I need to get in touch with the Florida Department of Environmental Protection if I want to look to get a potential permit letter saying that it wasn't impacting it in a great amount, or figure out if I need to go ahead with with paying any kind of a mitigation fee. After that had been done, I was trying to get in contact with my original contractor. We'd been waiting to get this wetlands delineation done. Barry Johnson has not been very forthcoming with me or in a lot of communication, so I need to find another contractor that can help me get plans for the structure so that I can start the application process. But while I'm doing that, I need to figure out how to contact the Florida Department of Environmental Protection. If there's somebody with your department that I can contact to get that going.
So is there someone, Megan, is this but is this who would have indicated to him that he needed environmental?
That would have been Sarah, and I guarantee you she provided all of that information when she met with you or directed you previously. That information is easily available on the website if you Google Florida Department of Environmental Protection.
I can contact them through the website?
If you Google Florida Department of Environmental Protection, there's a Central Florida division. If you want to go to the second floor to the central intake desk, they will be able to provide you with a wetlands brochure that has the current contact information for DEP, St. John's, all of the various departments that you may need to contact.
So when you originally came here, you just needed a permit for the structure. And so for the last 5 months, when were you told that DEP needed to be involved?
I can give you a copy of the email.
So ma'am, probably what happened is when he got the delineation, there were probably impacts done to the wetlands that he now needs to mitigate for. So he can either mitigate on-site or he can pay into the mitigation bank. So it's up to him how he decides to mitigate the impacts, depending on how he impacted them, and that's up to him on how he is going to correct those impacts to the wetlands.
Okay, so it appears that you started these communications in June.
Yep.
So what happened between March and June?
It was getting Storm Richards and the surveyor together so that Storm could actually be on site to do the wetlands delineation. I'd been talking to them for a few months. It took some time.
And that
to
does
get them out
track,
there.
ma'am. Those do take quite a bit of time.
Okay, so it did, you knew immediately in March when you were here that you needed to get the wetlands delineation that had already been?
That's what came out of that hearing, yeah.
Okay. Okay, so now that you still need to get in contact with DEP though.
And I'm going to tell you that that is not a fast process.
In the meantime, I can get in touch with the contractor and start permitting, or no? I have to wait for DEP?
You can continue the permitting process. You will not get approvals until your mitigation has been procured.
But I can at least get that process started.
Whether you mitigate on-site, if you can mitigate on-site, or buying into the mitigation bank. And again, you can talk to staff upstairs whether or not you can mitigate on site, whether you buy another piece of property to mitigate or you pay into the mitigation bank. So again, you can contact Sarah, talk to staff upstairs, or purchase mitigation credits.
So he can apply for the permit, he can receive a permit, he just can't get it finalized until he gets everything taken care of.
He more than likely will not get through staff. He will get comments saying that he needs to mitigate in some fashion for impacts into wetlands.
Okay, but I think that the filing of the permit application and starting that process is probably going to be helpful.
Yeah, I would think so.
Okay.
And probably for DEP too, because they're going to want to see the same plans and everything that probably that we're going to want to see.
All right, that makes sense.
Okay, so we're probably looking at November 13th again on this one. Okay, so I'll go ahead and I'll continue to November 13th with everything else in the prior order staying in effect.
Okay.
Thank you.
Thank you.
You can have this back. Thank you. I think that resolves everyone we have present, or is there? 24, 26, okay.
So the first one
Which one we do?
Oh, I was looking at the wrong one. 2213 CESM.
I was like, you did not. That one's, I know that one.
And if you'll please raise your right hand, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, can you state your name and affiliation for the record?
Maria Echeverria, that's my dad, Victor Echeverria.
Okay.
Jason Rucker, Seminole County Building Department Inspector. This is case number 2213 CESM for Victor, I'm going to mess it up, Echeverria, for address 499 Rocky Brook Court, Castleberry. This case was originally heard by Special Magistrate on February 10th, 2022, and an order was issued giving the respondent a compliance date of June 10th, 2022. On June 9th, 2022, Special Magistrate issued an order extending the compliance date to August 11th, 2022. An affidavit of noncompliance was filed by the inspector after reinspection on August 12th, 2022. On March 9th, 2023, an order was issued extending the compliance date to April 8th, 2023, and waiving any accrued fines. An affidavit of compliance was filed on March 23, 2023, after the permit was obtained, closing this case. An affidavit of repeat violation was filed by the inspector after reinspection on June 12, 2024. An affidavit of noncompliance was filed by the inspector after reinspection August 6, 2024. The administrative cost process for the clerk was $270.84. The administrative cost for the inspector was $330.73, totaling amount of $601.57 for both the inspector and the clerk. Recommendation based on the findings of fact issued on April 14, 2022, the special magistrate issued an order imposing a lien in the amount of $2,900 for 58 days of noncompliance from June 12, 2024 through and including August 8, 2024. And the fine shall continue to accrue at $50 per day for each day the violation continue or is repeated after August 8, 2024. That concludes my presentation.
Do you have any objection to the electronic case file being submitted into the record?
No.
Okay.
Yeah, we started this project without a permit. Then I came here, talked to you guys, did give me the extension, got the permits out. Due to family hardships, mom health, getting a divorce, everything just went down the drain, and it has taken me too long of a time for me to put myself back together and keep on going with the project. So I'm working with the building department. The permit expired, and I'm working with the building department to have an extension, working with a contractor now, a pool company, that is telling me they can build a pool within 2 to 3 months. Now I'm getting into financing the project. The reason why it's taking too long, when we started it, we had to move the pool 5 feet more towers and remove all the rebar, so the first inspection could be done. Those pictures are pretty old. Now the reframe was done, the pre-plumbing was done, but the first inspection was never scheduled. And now the permit expired. And now because of the new code, I need to have new plans to show to them with the new codes that is, that just change.
So talk to me a second about the compliance. How did it come into compliance?
They were able to obtain a permit.
Okay, so because they obtained this permit in 2022, that's what brought them into compliance?
Correct.
Now, work has started again without the proper permit being pulled?
The permit expired,
Okay,
and apparently they have redone things.
Well, while we had the permit. So what we did while we had the permit, we removed the rebars because it was too close to the fence. Like in the county of Seminole, it needs to be 10 feet away from the fence, and we were 5 feet. So we had to remove all the rebar and move 5 more feet. That we did while we had the permit. Then we did the frame on that. Those pictures are old. So we did the frame on the pool, and we did the pre-plumbing. So what I never did was schedule for the first inspection.
Okay, so it never got any inspections? so-
No, because what I just stated, I had family hardship.
The case was reopened due to repeat violation. Permit for pool, fence, safety barrier pool have expired without inspections. Opened case with building official approval. Affidavit of repeat violation filed for 2213 CESM, as it has been less than 5 years from the last order. It's health and safety, yes.
well, explain to me though when the permit would have expired. If it was issued on August 9th, 2022.
6 months after
Okay.
the date of the issuance.
And I paid for an extension after the permit expired. And the reason why they couldn't give me an extension now is because the code changes.
Okay, hold on a moment, because
12/11/23 is when it expired.
Okay, it expired 12/11/23, but the case was complied on March 23rd, 2023. So if the permit had expired in December, why was it complied on March 23rd, 2023?
Because the permit was issued. As soon as the permit is issued,
But you told me it expired on December 11th. So if it was,
2023.
right, but if it was expired, then why did you all comply it in March of 2023 if it, just because it was issued, period?
Yes, when a permit gets issued, then they come into compliance as soon as it's issued.
So the affidavit of compliance wasn't filed till 3 months after it came into compliance, or after it expired?
Well, that's December 11th, 2023, so that would be after March of 2023.
Oh, you're right. Goodness, I'm sorry.
I'm sorry, I was a little confused, I'm sorry.
I am so sorry. I was,
I'm sorry.
okay, so she did receive an extension, but complied prior to. Now, I'm trying to figure out so work, obviously something looked different in the field, so work was done again, which is why, and now there's not another permit.
Well, according to her, it was done under the original permit. So once it was done under the original permit and there were no inspections, then it's voided after 6 months. So that December 11th date, the permit would have expired. Okay? So now, because there was a code change, she would have to come back in with all the permit requirements, plans, whatnot, to obtain a new permit and basically start over again.
No, I don't have to start all over again because I already spoke to them. And since I had a permit and they say that all I have to do is just bring like the new plans of the codes that have changed, and just like for them to revise the new plans.
Okay, so she would have to do a revision. She would keep the same permit, and they would just renew the permit.
And so in the in-between time, because we're talking over a year, that the hole has sat in
So
your
now-
backyard?
Yeah, so now, like I said, that project, I started it with my then husband, and last year in February, we got separated, so I was left with that project on my own.
But Victor's your father?
Victor is my dad. My dad just comes here, like, probably spend like 5-6 months of the year here, like during the winter.
So you live in your father's home?
Yes.
Okay.
Yes.
Okay.
So it's like my home, pretty much. My dad just comes during the winter. But I'm the one who's responsible of everything that happens in the house.
Okay. So between March of last year and now, you've just...
Pretty much, yeah, like, not like that. Like I said, while we had the permit, the pool was moved 5 more feet away from the fence. The rebar was taken out. They did the framing and they did the pre-plumbing. And that's how it is right now.
Under the old permit?
Under the old permit, correct.
And so they had to have done all of that prior to December of 2023?
Yes, yeah, like, I was ready to have the first inspection, but like I said, I've been going through like a lot of family hardship, and I just was not myself, then, so I didn't take care of it. Now, I'm working with a pool company, trying to hire a pool company and they are the one who's taking care of the new plans, so that way I can take this and finance the pool, because I can no longer do it on my own.
When you received the notice of, the affidavit of the repeat violation in June, what did you do?
I don't think I received it in June. I got this probably like a month ago.
For this hearing, yes.
For this hearing.
But there was a affidavit of repeat violation, so would that have been sent to her? Okay, so there was when did you start talking to the new contractor again?
Yeah, probably like a month ago. Because like I said, I didn't want to finance and put, more debt in top, so wanted like to do it with my own money little by little, but that's not working. So now I'm walking into financing so this can be done.
Okay.
And they're telling me like within 2 to 3 months, like they will finish the project.
Well, they can't finish the project till they get a permit.
Yeah, but that's,
Okay.
like I said, they're working on the plan, so pretty much by next week, I will have the new plans, send it to the building department for them to revise and they give me the extension, and with that, I can start again.
Okay. So the county has indicated that they are willing to give you till October 9th to get your permit issued. I'm going to go ahead and do that, but this is a repeat violation, so if you do not come into compliance, I'm going to order that a fine of $500 a day will be imposed because it's a repeat.
Okay.
And this is a safety issue for you to have a hole in your backyard like that.
I know.
So if you do not have your permit by October 9th, it will be $500 a day, retroactive to the date of noncompliance being June 12th, 2024. So your fine will be imposed retroactively. I'm not going to impose administrative costs at this time, but if we are back here October 9th and I have to impose the penalty of $500 a day, I will most certainly impose costs at that time.
Yeah,
Okay?
I should be done by then.
Okay.
Thank you so much.
Thank you. And the last one's here also, this one. 2426 CESM, Los Campos de America LLC. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you.
Jason Rucker, Seminole County Building Department Inspector. This is case number 2426 CSM, Los Campos de America, William A. Ramirez, for address 345 Jones Avenue, Sanford, Florida. This case was originally heard by the Special Magistrate on May 9th, 2024, and an order was issued giving the respondents a compliance date of July 10th, 2024, with a meeting scheduled for July 11th, 2024. On July 11th, 2024, an order was issued giving the respondents a compliance date of August 7th, with a meeting on August 8, 2024. An affidavit of noncompliance was filed by the inspector after reinspection on August 6, 2024. Estimated cost, administrative cost for the inspector was $594.51. The estimated administrative cost for the clerk was $154.86. for a total of $749.37 for both the inspector and the clerk. Recommend special magistrate issue an order imposing an administrative cost totaling $749.37 and require these costs to be paid within 30 days or a fine will constitute a lien on the property. That concludes my presentation.
Okay. Go ahead.
Well, we did not know that an inspector came 2 days ago. And as far as we know, we are in compliance with everything, but we still do not have a permit. But the last time that we were here, Your Honor instructed us to get a special permit because that is a residence inside a commercial parcel. I thought that was the reason that we came here today. And
You have the prior order.
you told me to go to the second floor and apply for a special permit.
Are you the owner?
Mr. Ramirez is the owner.
Okay, so then let's redo this a little bit. Can you state your name, please?
Robert Harnus.
Okay, and are you going to be translating for
Yes,
him?
Yes, he speaks English too. But I usually translate for him, yes.
Okay. Then I need to swear you in as a translator
Okay.
rather than providing testimony. He needs to be the one providing testimony because you can't provide testimony as a translator.
Okay.
Okay? Do you solemnly swear or affirm that you will translate from Spanish to English and English to Spanish to the best of your ability?
Yes, ma'am.
Okay. So if you can speak to this, I need you to try to, and if you can't,
Not very well.
okay, then you can
That's what
speak in Spanish to him, and he can tell us what you're saying, okay? Let me look at my prior order. Okay, so this is just the amended order. Is there a order prior to that? Okay, and this, again, is just, it doesn't, Is there something about this case that there is a special permit? I do remember this being a residential structure.
Hi.
Hi.
In Planning and Development, I'm a planner.
Okay.
They were supposed to apply.
Let me
I'm
swear
sorry.
you in. Nope, you're good. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can go ahead.
So they applied for a pre-application, which is the first step to get a special exception. In order for them to get a special exception, they would need to go through that process. The pre-application is just basically an inquiry into the county on,
can I do this?
right, can I do this? So they were supposed to have a DRC meeting yesterday morning for that pre-app, and they did not show. The next step would be for them to apply for a special exception. They would need to hold a community meeting and then go through two public hearings with PNC and BCC to see if the special exception can be granted.
Okay, and even though they didn't show for DRC yesterday, they don't have an official application in, so
They do
it
not.
doesn't roll forward to the next step or
That's
anything?
correct. They would still need to apply for the special exception.
Okay. Can you translate that to him, please?
Que teníamos que haber venido a una reunión ayer y que teníamos que aplicar para la excepción especial.
And do you understand that you had a meeting yesterday that you did not show for?
No, I spoke with a lady and she told us that they were going to schedule a meeting on Wednesday, but we never received that email with the confirmation of the date and the time. And the application, we already filled it out upstairs.
Did you submit it?
Yeah, we paid for it already and they gave us a copy of what they,
When did you do that?
the last time that we were here, that you instructed us to go upstairs.
That's just the pre-application, that's not the actual special exception.
Okay. And we never received the scheduled meeting for yesterday. They told us over the phone that it was going to be on a Wednesday, that they was going to let us know when and the date and the time. We never received. I just checked my email just now. We never received that email.
So, does the DRC phase and the pre-application have to occur, or could someone just submit their application?
The DRC phase for the pre-application, no, they don't have to have the meeting, but that's where they would have received that explanation. I emailed them comments letting them know that they needed to apply for the special exception. Now they just need to move forward with the actual application.
Okay, and sir, did you receive an email related to needing to apply for the special exception?
No, I spoke with Hillary Payton.
That's me.
That's you? And you told me, send me an email, I want to come in person. And you told me over the phone, I'm going to call you back or send you an email with the date and time. I never received that.
They send out an email on Friday to all the applicants with a link to the meeting agenda for,
There's the confirmation of it right there.
okay. And we have a confirmation email that shows from the clerk from Friday that the email was sent to your email addresses.
We never got it then. The last email that I have from
It was
you
from
is
Heather
the-
Ryan. It was not from me. It was from Heather Ryan.
Unless it went to the spam, then I never got it, because the last conversation that I had here is July 31st.
Okay.
Okay, and then the county is saying that they did send you an email. So,
To confirm, it was the email that coincides with the company name at AOL.com.
Correct, Los Campos de America.
So that is the email that it was sent to, which was the email that would have corresponded to what was provided on the application.
okay,
We never got it.
okay. So,
What's her name again?
Heather Ryan.
Or it would have come from DevRev, probably.
Or maybe it might have come from DevRevDesk@SeminoleCountyFL.gov.
I just checked all my Seminole County emails, and
Okay. Well, the pre-app DRC meeting, it's not a requirement. It's an option if they wanted to have, discussions regarding their comments. So the next step would just be for them to apply for this actual special exception.
okay.
and where do we do that?
The same place that you applied for the pre-application.
Okay.
So, for the record, I'm going to, Mr. Harness, I'm going to recognize you as a representative of the owner of the property.
Thank you.
Because you have been basically testifying and talking to all of the people for him.
I'm very familiar with.
Okay, okay. But the last time we were here, we gave another continuance, and now we're here again where you've not done anything further.
Well, you instructed us to do this, and we did. That was the last thing that you told us. We never heard back about the meeting yesterday to do an application.
Okay.
Now we know.
So you needed to do the special exception application period. This is the pre-application meeting. So the special exception is what I needed you to do. And that still is necessary because we can't get to the next step that we need to do for the reason that we have this case, which is the building permit part of this, but until you get the special exception.
Okay.
In the meantime, is anyone living in the
No, there's no one
The
living there
structure.
right now, no.
Okay.
Can he bring in some furniture in? No, no?
No, not until there are permits.
Okay.
Does the county have any objection to additional time so that they can go through this process appropriately now, as long as no one is living in the structure? How long would it take?
Dale Hall again for the record.
Yes, sir.
First of all, I'll start saying it's highly recommended they go through the pre-application, because going right to the special exception application, it's not going to be complete, and they're not going to be able to, they're not going to get the proper information to a complete application.
Okay.
So another 30 days for that application to put us on the DRC meeting would be fine for their pre-application meeting, and then it's going to take another 30 days minimum again to get to your special application to be reviewed with comments. Now, scheduling for that is even further out than that.
Right, and then hearings, obviously, if there are two of them, you've got P&Z, you've got BCC, so we're looking 4 months at the minimum if everything is done perfectly. And so more like 6 months.
Right.
So what they're telling you, though, is that, so if he stays with the pre-application and does do DRC, does he have to file again, or is his existing application sufficient and you'll just reschedule?
We could reschedule this pre-application he has submitted for a future date.
Okay. So are you understanding what they're saying? They think that you should go through the pre-application process to help you with the next process, which is more involved? And that if you file that and you accept that and get through that part, then there are 2 hearings beyond that. So you're looking around 6 months for the entire process. But you've got to pay attention to your emails. You have to.
Well, we did not receive that email. Can we come to that meeting next Wednesday? Do the pre-application?
The meeting will not be scheduled for next Wednesday. It'll be scheduled for a future event, and I don't have the calendar in front of me, so
Okay.
a month.
In about a month?
Sorry. I can also just meet with you directly, and then we can discuss the special exception process directly. I don't think we really need to have a formal meeting to do that.
Okay.
So if you want to expedite it, we can do that.
Okay.
Okay?
Okay, if you would give your information to him, that would be fantastic, and then that would help you all get to that next step faster. And so now I need you to go out of your way, because it sounds to me like the county is going out of their way to make sure that they are meeting with you and helping you through the process. So I don't want to give you 6 months and hear that there is, you've not done anything.
No, I'm going to schedule a meeting with her today for whatever day she has availability. Now, what are we going to do about the other violations?
Well, that's what would be continued, because in this time period, this 6-month time period, I'm wanting you to do the things you need to do to file for your permit as well.
Okay.
And so in doing that, you've got to have probably engineered drawings and everything that you need for that structure.
We have all that.
Okay. All right, then could that be applied for now, the permits, knowing that he's doing the special exception kind of simultaneously.
It wouldn't be recommended at this time until the application is done to submit for the building permit. So you would at least have to run them concurrently at a minimum.
Okay, so he could start the building permit process, but really not till he starts the special exception process, so maybe they're kind of going together?
Yeah, that's not a standard process we do, but we could, in certain instances, consider that.
Okay, so if you have everything, you maybe could start the process. Now, they may tell you, okay, we still need you to go through the special exception, but as long as you're continuing to keep the lines of communication open with what you have so that you can get comments, I think that's going to be the best.
They already have an application.
Oh, they do?
It's already in there, it's in PC status.
Okay, so we're just waiting on
We're
the
waiting
special
on-
exception?
yes.
Okay. Okay, then I'm going to go ahead and change your compliance date to what is our February 2025 look like?
Second Thursday of the month, right?
Oh, you got, look at you, thank you. Okay, so February 12th, just in time for Valentine's Day. You're going to have it.
Now, if an inspector is going to come, will they let us know that they're coming? Like they did not notify us that they were coming a couple of days ago to the property, and we are not there on Tuesdays or Wednesdays.
Well, I think it was just Jason that came to
It's just
see.
for reinspection to make sure all the violations were still there.
Okay.
That you hadn't taken the structure down or anything like that. So it's just a follow-up inspection. It's nothing major. I didn't walk around the house or anything. I just took a picture from the street.
So after we fill out the application with this lady here, you will let us know when the permit has been approved, so we can continue with the construction?
You have several steps to go through before we get to that point.
Okay.
So you'll have to satisfy everything with them first.
Okay.
Okay, so I'm going to go ahead and continue the case to February 12th, 2025, the compliance date with everything else remaining the same.
Okay. Thank you very much.
Thank you. Okay, are we out of people? All right. Does anyone need to take a break? I'm so sorry. If anyone needs to, it's completely fine. You tell me. Let's go? I think just a few. Okay.
I mean, do you need a break?
No, I don't. I'm good.
Jason, plenty of water.
Food, yeah. Okay. 2451 CESM, Lori and Gregory Harrington.
Jason Rucker, Seminole County Building Department Inspector. This is case 2451 CESM. Is for the property located at 2114 Winnebago Trail, Warren Park, owned by Lori and Gregory Harrington. Violation charge, Seminole County Code, Chapter 40, Appendix A, 105.1. Violation is resurfacing of a pool without the required permits. The initial inspection was done on 10/31/23. A notice to the respondent was sent 11/1/23. There have been a couple of compliance dates and extensions given. Follow-up inspection shows both on the site and via the computer. The results of the inspection was a violation remains on the property. This is a property appraiser's website that shows they are the owner of record. They were properly noticed. We got the green card back. And here are the pictures of the violation where you see them resurfacing the pool. Stop work order was issued. This screen shows that no permits have been applied for or issued to correct the violation. Next slide is the copy of Chapter 40 of where they're in violation. Based on the testimony and evidence presented in case number 2451 CESM, it is determined that the respondents are the owner of record of the property at 2114 Winnebago Trail, in possession and control of the property, and in violation of the Seminole County Code, Chapter 40, Appendix A, 105.1. I further recommend that the special magistrate order the respondent to correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and asked for it to be submitted into record. That concludes my presentation.
And find that the property owners, Laura and Gregory Harrington, were properly noticed to be here today, and they are not present to participate in the hearing. I'm going to find that there is a violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, and I am going to order that the property be brought into compliance by September 11th, 2024, with a compliance hearing of September 12th, 2024, or a fine in the amount of $250 a day will be imposed. (2458) CESM Christopher Belcher.
Jason Rucker, Inspector, Seminole County. This is case number 2458 CESM. Is for the property located at 657 River Park Circle, which is owned by Christopher M. Belcher. Violation charges Seminole County Code, Chapter 40, Appendix A, 105.1, and is for the installation of a screen enclosure without a permit. The initial inspection was done on 8/14, as well as a notice to the respondent was done on 8/14. They have been given compliance dates and extensions, and the follow-up inspection on-site and by the computer have been done, and the violation remains on the property. This is the property appraiser's website page that shows that Christopher Blanchard is the owner of record. We did post the property for the notice of this hearing, and here are some pictures of the violation that's still there, and some pictures of when it was originally cited. Some of them are hard to see. Okay. This shows that he's had several permits, but no permits for the screen enclosure. It does show that received on 9/12/23 to correct the violation, but the application is under review and has not been issued permit due to required corrections from the building department. So he did apply for it, but never followed through.
When did he apply?
9/12/23. The next screen shows the application. It's been awaiting plan check since 5/16/24. The next slide shows the copy of the code that was cited. Based on the testimony and evidence presented in case number 2458 CESM, it is determined that the respondent is the owner of record of the property located at 657 River Park Circle, in possession and control of the property, and is in violation of Seminole County Code Chapter 40, Appendix A, 105.1. Further recommend special magistrate order the respondent correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request that it be entered into record. That concludes my presentation.
Okay, I will accept the electronic case file into the record, and we'll go back on, and I'll accept the other in a moment. Did the property owner, did you mail notice to? I know, I didn't see the green card, I saw the posting, but was there notice
I
mailed?
think we posted. I think the green card may have come back, but it wasn't signed.
Like they refused it? Do you send regular mail too, or just, so you sent regular mail, the regular mail didn't return, but the green card was refused?
Correct. From what I understand, we're going to see right here. Give me a second.
Are you looking for the green card for the NOH?
Oh, probably the whole letter that came back.
This is everything that came back.
Okay, so yeah, all the letters came back, all the certified mail came back. The whole thing come back.
Just certified.
Just certified. Did regular mail come back? Okay. I'm going to go ahead and find that the property owner was properly noticed to be here today and they're not present to participate. I'm going to find that they are in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, in order that they come into compliance by September 11th or receive a penalty of up to $150 a day for each and every day after September 11th that the violation remains. Okay, the next case, 2288 CESM, Ronald and Kelly Simon.
Jason Rucker, Seminole County Inspector. This is case number 2288 CESM, Ronald and Kelly Simon, located at 2071 Wood Thrash Lane. This case was originally heard by Special Magistrate on October 13th, 2022, and an order was issued giving the respondent a compliance date of January 12th, 2023, with a fine of $50 per day continued to accrue for each day the violation continued or was repeated after January 12th, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on January 24th, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on August 6th, 2024. Administrative cost to process the case for the clerk was $125.61. The administrative cost to process this case for the inspector was $808.75, totaling $934.36 for both the inspector and the clerk. Recommend Special Magistrate issue an order constituting a lien in the amount of $28,750 for 575 days of noncompliance from January 12, 2023 through and including August 8, 2024 at $50 per day, and a fine shall constitute and accrue at $50 per day for each day the violation continues or is repeated after August 8, 2024. That concludes my presentation.
Did they receive notice of this hearing today? You received the green card back? Okay. Perfect.
There's the business. Yep.
Okay. I'm going to find that Kelly and Ronald Simon were properly noticed to be here today. I'm going to find that the property remains out of compliance still, and they were ordered to come into compliance by January 24th, 2023, and so I'm going to order that the penalty of $50 a day that was imposed on the order dated January 12th, 2023 be ratified, and a lien in the amount of $28,750 will be imposed for 575 days of noncompliance from the date of original compliance through August 8th, 2024, and will continue at a rate of $50 a day for each and every day hereafter that the violation remains. I will also impose administrative costs in the amount of $934.36 to be paid within 30 days, or they too will be imposed as a lien against the property. And 2340 CESM, Leticia Morales.
Jason Rucker, Inspector, Seminole County. This is case number 2340 CESM, Leticia Morales, 300 Ridge Road, Fern Park. This case was originally heard by Special Magistrate on April 13th, 2023, and an order was issued giving the respondent a compliance date of July 13th, 2023. An affidavit of noncompliance was filed by the inspector after reinspection on July 17th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on August 6th, 2024. Administrative cost for the inspector totals $688.24. The administrative cost for the clerk totals $125.61. To date, it totals together $813.85 for the inspector and the clerk. Recommend the special magistrate issue an order constituting a lien in the amount of $19,650 for 393 days of noncompliance from July 13th, 2023 through and including August 8th, 2024. A $50 per day and a fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after August 8th, 2024. That concludes my presentation.
And how were they noticed to be here today?
I believe the property was posted, correct? No, it was signed green card back.
Okay. I'm going to order that the property owner, Leticia Morales, was properly noticed to be here today and that she has not shown up to participate. I'm going to order that the property is still out of compliance with the order that was entered on April 13th, 2023, and requiring that the property be brought into compliance by July 13th, 2023. I'm going to order that the fine be imposed as of July 13th, 2023, in the amount of $19,650, and then it will continue to accrue at a rate of $50 a day from today until such time as the property is brought into compliance. I'm going to order administrative costs in the amount of $813.85 be paid within 30 days of the date hereof, or it too will be imposed as a lien against the property. I think this concludes the cases. We'll go ahead and set our next hearing date for September 12th, 2024.